as the crisis of COVID haunts us, to take our mind away from all these negative things, we started exactly 1 year ago on the 23rd of April 2020. We started Littles. The situation has not changed. The only thing that has changed is that we have been enlightened, exposed to different thoughts and ideas. And in fact, it was a journey of empowerment, legal empowerment through interaction. Today also, we are reeling under this crisis. We are getting bad news, mixed. I don't know how to deal with all these things, but still, let us take our mind away from this for some time and let us continue our journey of empowerment and discovery. Today, in the 198th session of Legal Empowerment through Interaction Lecture Series, we have a very wonderful speaker, a senior advocate of the Supreme Court, Sri.Mohan Katarki sir, and a special thanks to Justice Sunil Thomas sir for introducing the wonderful speaker to this platform and for also agreeing to deliver the introductory remarks. Indebted to Justice Ramkumar sir, who is present today, and all of you wonderful participants. So without wasting any time, let us go directly onto the topic. May I request, on behalf of this extended family of Letils, Justice Sunil Thomas sir, to deliver the introductory remarks.
Distinguished guest, Mr. Mohan Katarki, Honorable Justice Ramkumar, other distinguished guests, a warm good evening to all of you. Today we have a very, very innovative topic, or rather I can say that it is a rather exceptional topic of dam safety and the state responsibility. As you all know, in India we have got about 5,000 dams across the various rivers of India, large dams of around 5,000 in number. And apart from the usual sociological or environmental or climatic issues that may arise out of construction of large dams, there is one issue which has always been sidelined, that's the safety of the dam. Most of our dams were constructed around somewhere in 1947, prior to 1947 and thereafter, around 1947, immediately after the independence. So they have crossed the age of more than 50 years. And what is the responsibility of the state in relation to a possible safety threat arising out of a collapse of a dam? It's a rare phenomena, but we had examples of collapse of dams in India. We know the example of Morbi Dam. We also know the example of Kadakvasla Dam. And even outside India, there have been instances of dams collapsing, resulting in huge loss to public money as well as property. What is the responsibility of the state in that? This involves various issues, various complex issues. It may be a case where the state is responsible to its citizens. It may be a case wherein a state will be responsible to another state for the damage that may be caused. One of the typical examples that assumed prominence in recent times is the case of Mullaperiyar Dam in Kerala. That's a dam which is situated in India but manned and controlled by the state of Tamil Nadu for their benefit on the basis of an agreement which was executed in the year 1895. And the dam has crossed 125 years. The lease period was extended to 999 years, which nobody could imagine. Very long period, we do not know whether the dam will survive during that period. If something unfortunate happens, what will be the consequence? If it collapses due to the responsibility or lack of proper maintenance from the outer part state, are they responsible to the state of Kerala? This issue may arise a national, it should become a national issue wherein dams are constructed by the union government in the state participation. We have got a lot of dams constructed by the central government participation, or by a corporation in which the central government has got larger part to play. So these are the issues that arise while considering this. What will be the responsibility of the upper riparian state to a lower downward riparian state in case of such collapse? Is the liability confined to mere damages or a criminal liability also? It may affect the federal structure of the state when two or more states are issued. Then should we have a national policy of dam safety? Should we have a national statute which will take care of all these issues, including fixing the responsibility on the state responsible for the damage? Apart from that, there may be a question what should be the role of courts when issue regarding safety of a dam is brought up. These are the larger issues which we expect to discuss and which we have got today with us, and a very eminent speaker, Mr. Mohan Katarki, who is the Senior Advocate of Supreme Court of India. He has got deep knowledge on water laws, and he deals with a variety of subjects. He has written various articles on climatic changes, environmental issues, and starting up to the issues relating to providing minimum support price to the agriculturists. Probably he has covered all the major issues that have come across which India is facing now. And I was fortunate to have him witness or watch cross-examining witnesses in original suits involving states. In one of the disputes, were in four or five states were involved. He was representing the state of Punjab. In another water dispute which was pending before the Supreme Court, I have seen him conducting cases on behalf of the state of Karnataka. Anyway, he is a wonderful speaker, having good knowledge in law, and he has, I can definitely say that he has imbibed the qualities of his mentor, the legendary Thalius Thurman. So over to you, sir. Welcome you on behalf of Letils and on behalf of. Over to you, Mr. Mohan Katarki.
Thank you, Justice Sunil Thomas, sir. Sir, Mohan Katarki, sir, it's all yours. Can I play the video?
Yes.
Yeah.
Water is an unstoppable force that we cannot fully control. A wall of water can wipe an entire city right off the map in just minutes. From a recent dam disaster in China to a double dam failure in the USA. Check out these craziest dam disasters that were caught on camera. Plus, make sure to stick around until the end for a bonus disaster that you'll have to see to believe. Three Gorges Dam Flood. China's massive Three Gorges Dam is said to be on the verge of collapse any day now because of flooding that began on July 19, 2020. Over 2.1 million cubic feet of water per second hit the dam's reservoir. The dam's operator said that the 1.4-mile-long, 606-foot-high structure had shifted, leaked, and has become deformed. That doesn't sound good, but they claim the dam was functioning well and is safe to use. Many provinces along the downstreams of the Yangtze River have seen large parts of land covered in floodwaters. There was a lot of speculation that the Three Gorges Dam, which is the world's largest hydroelectric plant, could completely collapse under the continued pressure from more flooding. An amateur CGI video by an unknown source shows the Three Gorges Dam collapsing, which many fear shows towns and cities in the lower reaches of the Yangtze River quickly becoming submerged underwater. It would be an incredibly catastrophic scenario if this happens. Just don't be surprised if you hear this dam breaking any day now as it continues to be hit by floodwaters. Brumadinho Dam. An incident with a very bad ending is that of the Brumadinho Dam in Brazil. On January 25, 2019, an iron ore mine tailings dam at the Córrego do Feijão collapsed, releasing 425 million cubic feet of toxic mud into the whole Brumadinho area. The destructive flow of debris flooded the mine's cafeteria and offices and nearby downstream communities. The incident resulted in the death of 270 people, most of whom were Vale employees. Further, 3 locomotives and 132 wagons were buried by the mud, and 2 sections of railway bridge were destroyed. To make matters worse, the environmental damage was incredibly bad, and it was estimated that the tailings polluted over 185 miles of river with toxic chemical elements. The company that owned the dam said that there was no evidence of a risk of collapse since the infrastructure's water pressure was monitored frequently and consistently. However, a string of media posts showed that the company was aware of several significant structural dam issues and classified the dam at Brumadinho as being 2 times more likely to fail than the maximum level of risk tolerated under internal guidelines. Until now, there was no investigation of the Brumadinho tailing dam disaster and why it failed. We wonder why, but some experts suggest that the water was gradually penetrating the tailings dam, causing saturation of the soil. Due to the chronic weakening of the soil, the dam collapsed and destroyed everything in its path. The penalties for the company owning Vale? The equivalent of $50 million in environmental fees, $3 billion of assets getting frozen from the authorities, and 16 individuals being charged as responsible. This is an example of what happens when danger signs are ignored by officials. Before we move forward, we have a quick favor to ask of you. Subscribe and turn on notifications, and you'll never witness a dam break in your city. Don't miss out on this incredible offer. Subscribe today. Mariana Dam Disaster. Now moving on, we make our way to Brazil. A few years before the Brumadinho Dam incident, a dam owned by the company Samarco suffered a similar catastrophic failure. On November 5, 2015, the Fundão Tailings Dam at the Germano iron ore mine near Mariana, Minas Gerais, Brazil, collapsed, causing a flood that destroyed the downstream villages of Bento Rodrigues and Paracatu de Baixo. The incident killed 19 people, while more than 1,500 million cubic feet of mine tailings ended into the Doce River, polluting 445 miles of watercourses before ending in the Atlantic Ocean. Samarco received a fine of 20 billion Brazilian reais, or approximately $4.8 billion, not including compensation to people affected by the disaster and the cost of recovering the polluted area. Ituango Dam failure. Another incident with a devastating ending is that of the Pescadero Ituango Dam. This facility is an under-construction 738-foot-tall embankment dam on the Cauca River near Ituango in Colombia, which will have a reservoir capacity of 670 million cubic feet. When completed, the dam will be used for hydroelectric power generation with a capacity of 2,456 megawatts, making it the largest power station in Colombia. However, on April 28, 2018, when the dam was just only a few months away from its completion, 3 landslides blocked the only tunnel which was responsible for diverting the river's flow during the construction phase, leading the reservoir to fill. The 2 other diversion tunnels, which were used in the past for water flow diversion, were already blocked at this point since the project was very close to completion. The result? There was no outlet to divert the water flow, and the dam's water level started to rise dangerously. In their efforts to reduce it, the engineers of the project began releasing water through the unfinished powerhouse to prevent a breach of the dam. This move seemed to work and released enough pressure from the structure. However, 2 days later, on May 12, 2018, the water pressure unclogged one of the sealed tunnels, which increased the downstream flows by 3 times the average. Almost 25,000 people evacuated their homes because of the uncontrollable flash floods. The village of Puerto Valdivia, which was directly in the path of the flood, was heavily damaged, with 59 homes, a school, and a health center destroyed. This extreme situation was stabilized and temporary solutions were taken by the construction team to control the water flow. However, studies show that the Ituango Dam will most likely end up in a massive failure, inflicting severe ecological consequences to the whole ecosystem and jeopardize the safety of the communities living downstream from the half-constructed project. Oroville Dam crisis. In February 2017, the Oroville Dam faced an unrestrained crisis which could have cost the lives of thousands of people. This water facility is an earthen embankment on the Feather River east of the city of Oroville in Northern California and is responsible for flood control, water storage, hydroelectric power generation, and water quality improvement. It stores the water of the man-made Lake Oroville and is capable of storing more than 1.1 trillion US gallons. The heavy rainfall during the 2017 California floods created a very critical situation for the dam. The inflow of water in Lake Oroville rose from 30,000 cubic feet per second on February 6th to over 130,000 cubic feet per second on February 7th, to finally a peak of 190,435 cubic feet per second late on February 9th. The operators, trying to counteract the rising flow, increased the main spillway outflow but noticed an unusual flow pattern. They quickly stopped the water flow to examine the spillway, only to find out that a crater had formed right in the middle. In their attempt to control the rising inflow, the California Department of Water Resources decided to continue using the main spillway with a lower than normal flow, fully aware that this will further damage the main spillway. This wasn't enough, however, and on February 11, 2017, the Oroville Lake reached 901 feet above mean sea level, and the water started overflowing through the emergency spillway, which was used for the first time in history. Because of this uncontrollable outflow of water, the base of the dam started eroding at larger than expected levels, threatening to collapse the whole structure and flood the communities downstream. Fearing for the worst, about 23,000 National Guardsmen were ordered to help with the evacuation and relief efforts in case the dam spillway would fail. In record time, the 188,000 inhabitants of Oroville evacuated the area until the situation was taken under control. The authorities doubled the outflow through the damaged main spillway from 55,000 cubic feet per second to 100,000 cubic feet per second. Several hours later, the water level was successfully lowered and the overflowing stopped. The danger was finally averted and an enormous repair project was left in its place. Michigan dams collapse. The very recent collapse of two dams in central Michigan had a devastating effect on the lives of thousands of citizens. On the afternoon of May 19, 2020, heavy rainfall caused the Edenville Dam to collapse. Just hours after the Edenville Dam failure, the downstream Sanford Dam collapsed, which led to major flooding in the counties of Midland and Gladwin. The next morning, there were already several feet of water on the streets and the citizens were asked to seek shelter in higher ground. The downtown area of Midland went under 9 feet of water. Many buildings were ripped off their foundations and houses could be seen floating downstream. Bridges and roads were smashed. Lampposts were toppled and approximately 3,500 houses were damaged. The disaster caused at least $175 million in damage. Experts say that more incidents like that are quite likely to happen in the future since the majority of dams in the U.S. are poorly maintained and are not built to withstand extreme weather conditions. Bonus topic: Kiev pipe explosion. Okay, so this one is not a dam failure, but it's pretty crazy nonetheless. On May 29, 2017 in Kiev, Ukraine, water company officials decided they will test some 37-year-old water pipes before using them to see if they will hold. The result was a water pipe bursting with an incredible display of power, ripping up the asphalt like paper, damaging nearby cars, and showering the area with muddy water and rocks in all directions. In the aftermath, there was a 65-square-foot hole in the ground. The dramatic pipe explosion was caught on nearby CCTV cameras.
So, sir, that was the presentation, and when we learned the doctrine of strict liability, the example is valence versus fracture, wherein the breach of a reservoir is what is the criteria. I think this is the magnitude with which the power of water can be seen. Over to you, Mohan Katarki, sir, for the presentation.
Yeah. Thank you, Shyam. At the outset, may I thank you, Shyam, and the organizers for having me over to deliver a lecture. I thank Honorable Justice Sunil Thomas for introducing me to the webinar. Justice Thomas had been a great inspiration for the young lawyers in Delhi. He was the most successful registrar. Besides doing the administrative work, he conducted trials in the interstate disputes. There are a large number of suits pending in the Supreme Court, almost about half a dozen suits in which I was appearing. I used to regularly appear before him and conduct the cross-examination of very difficult witnesses. They're all engineers and scientists of national repute. Mr. Thomas is known for conducting the court proceedings in a very friendly manner. His art of court management was so good that none of us ever felt that we were cut short or were not allowed to put the questions which you want to put questions. At the same time, he was very firm. Whenever he felt something to be disallowed, he indeed disallowed. So, sir, it was really a great pleasure to have practiced before you. And I learned also a lot about cross-examination because I started my career in Supreme Court straightway. Incidentally, I got involved into the cross-examination of witnesses because it so happened one day in Mullapariyar matter, Harish Salve was not available. Then I was requested to start the cross-examination, and finally I had to complete the entire cross-examination of on a major witness of Tamil Nadu. Before that, I had little experience in Kaveri, but that Mullapariyar experience gave me a lot of confidence, and thereafter a couple of original suits before the Supreme Court, all that happened. And I really thank you for that. Going to the topic, the dam safety and the state responsibility. When Mr. Shyam spoke to me, whether we can make it dam safety and liability, I told him that the dam safety and liability could be a very narrow topic. Then would be addressing only on the private law or the actions in tort with regard to the liabilities of the dam owner. But what is important today is to have a comprehensive picture on the state responsibilities and the rights of the citizens against dam failures. The world is full of dams for the various reasons. There are dams constructed for hydropower, which just store the water and release and produce the power. But there are dams which store the water and retain it for a long time to irrigate the crops during the off-season. The shortage of food in the world forced the World Bank to fund hundreds of dams around the world. Most of the rivers in this world today are dammed. There's not a single river which is still a virgin river, except some west-flowing rivers, which we see in the west coast in India or some other places, which are short rivers, just run down. Even in the west coast in India, in Kerala you take, there are so many dams, but not as much as there are on the rivers which flow towards the east. The rivers which flow towards the east, like Kaveri, Krishna, Godavari, or Narmada, and Mahanadi also, that flows towards east. There are a series of dams in the basin. Each basin has at least a dozen dams, which are large dams, holding about 50 TMC of water or more to irrigate, to supply water to the irrigators. Around the world, the same is the portion. In Western United States of America, where this first technology of high dam construction started in the middle of the 19th century, have a series of large dams built to supply water to the farmers. The state of Colorado, which is really a headwater state, involved in series of litigations with the downstream states, like my state of Karnataka, or you see California, Utah, any of these states you take, the portion is same. Nobody thought seriously when these dams were constructed, what happens if there is a dam failure for any reasons? It's very unfortunate, but that's how the world functions, because everyone was so eager to dam the water and produce power or irrigate the crops and improve the incomes of the farmers, bring them out of the poverty. These are the things which are very high on the agenda of the world. Rightly so. Nobody should say anything about it, and they were rightly done. But if the dam fails, if the dam bursts, something happens, then what are the rights of the citizens? And what are the rights of the citizens to direct the state to take preventive steps? These things are not systematically thought over. Unfortunately, even in 2021, they are not thought over. India started constructing large dams, beginning with Mullaperiyar Dam in 1892, or several dams. Then after the independence, the first planning commission gave more importance to the irrigation, and funds also were diverted. Jawaharlal Nehru, the Prime Minister, made it openly clear that dams are the modern temples. To that extent, the construction of dam and the need of dam was elevated. In the last 70 years after independence or after the advent of planning commission, we have seen in every basin in India, except the basins in the northern states, that is Ganga, the dams have been built. In the perennial river, Ganges or Brahmaputra, dams are not constructed, not necessary to construct, unless there is a requirement for production of power. As far as irrigation is concerned, in Ganges and Brahmaputra, which irrigates the entire Hindi belt, we generally identify with UP, Bihar, and all West Bengal, they are by simple diversion structures. If you see at Haridwar, there is no dam, a simple diversion structure to divert the water. So that kind of a diversion structure exists in the entire Gangetic basin, so as in Brahmaputra. But Indus Basin has a dam called Bhakra. Though in Indus Basin also, to begin with, British started irrigating only by diversion structures. And large part of Punjab, which now lies partly in Pakistan, was irrigated only by diversion structures. There was no need for a large dam. But then they thought at some stage, that is much before independence, that we need a dam to enable farmers to grow the second crop in the post-monsoon season. And that's how the Bhakra Dam was initially planned in 1920. That led to the dispute, whatever, a separate chapter. Then in South also the same thing. Now all these dams are standing. Then what happens if something goes wrong? God forbid nothing happens. I don't think anything will happen. But something happens, what to do? And we can't say nothing has happened. Khadakosta Dam got washed out. Morbi Dam got washed out. It happened in China. Bangkok Dam killed 170,000 people when it collapsed. So these are the dangers which are real. They are not imaginary. If these dangers are real, and if the enormity of the damage is going to be huge, how to address this difficulty requires a serious thinking. Let me first start identifying, as lawyers understand, what are the state responsibilities in addressing the dangers arising from likely failure of the dams. The first responsibility of the state is, as we all know, imposition of the burden of payment of compensation in case the dam fails. Whether we should apply fault liability, no fault liability, that is strict liability, or the new concept of absolute liability is a different question, which I'll come to it later. But the most important thing is, which will address immediately the rights and concerns of the people, is enactment of a law to take care of the interest of the individuals. In India, though there is no statutory law, the common law takes care of it. Article 372 of the Constitution provides for continuation of the common law as an existing law. Therefore, we are well equipped to sue the state for damages if a dam fails. But there is one hurdle. Article 300 gives a sovereign immunity to the state, that whatever is considered as a sovereign function, you cannot sue a state. Most of these dams, 90% of the dams in this country, are constructed by the state governments, or some of them by the central government or central agencies like Hydropower Corporation. So this is a gray area whether a suit for damages will succeed against the state. The nature of damage is so high, probably judges may hold that the action doesn't lie. If a small dam of 20 TMC, I'll just take it, I won't want to name the exact dam, is going to fail. If it fails, it is going to really affect about 1 lakh people. About 15,000-20,000 may die. About 1 lakh of people may be displaced from their homes. Their property may be damaged. Now, if you calculate all the damages based upon the expectation theories, as we do in motor vehicle cases and other cases, land acquisition cases, for this 20 TMCF dam, state government may end up in paying 20,000 crore rupees. So it's not that easy to enforce private law, though private law is of great help in addressing the small claims against the small dam owners or some kind of a breaches happen. But if the dam collapse were to really happen, I doubt this is a viable remedy, and the suit may take years or decades. It will be almost worse than what we have seen in the Bhopal case. It will be worse than that. Maybe the state governments may file participatory suit, take over the rights of the, pass a law and take over the rights and file a suit in the civil court, whatever may happen. But again, the state government itself is the owner of the most of the dams. Why will do that? So this is a serious problem. The second responsibility of the state, which it owes to the people, is to create a disaster management system. Fortunately, in India, in the last 2 decades, we have a disaster management board, both at the national and the state level, which will immediately be activated if the disaster takes place. In fact, the same disaster management authority is operating presently to take care of pandemic, although there are arguments that this act was not meant for pandemic. But anyway, in the emergent circumstances, it is interpreted as it can take care of the pandemic also. So that's how the legal structure is erected today to handle the pandemic under the disaster management, though it was not expected to do. The Disaster Management Act is a great step, of course. It will immediately come to the rescue of the citizens who are affected by the floods. The failure of dam is ultimately nothing but release of water, which causes a flood in the downstream. So once the floods are in the downstream, if the water rises above 6 feet in any place wherever the people are staying, their life is in danger. Animals may die, children may die, all those who can't swim may be in trouble, all kind of thing, or there could be a secondary effect. The diseases may start, all kind of things will happen. So how to protect from this kind of a disaster? there have been various schemes to address to the difficulties of the people by locating them to the safer areas, supplying them the food. So all these things are taken care of. But these are all temporary remedies which are necessary, very necessary to save the life. But these do not address the real concerns of the people. If a person loses his house, if a person loses the bread earner in the family, you can't tell him that you cannot be compensated. Nothing can be done to you. Therefore, it is very essential that we think beyond the disaster management in tackling the difficulties. The third responsibility of the state is preventive measures. What preventive measures the state should take in order to stop or in order to control the owners who operate the dam. This is a preventive measure to see that the dam does not fail. It's also called risk management. With regard to the preventive measures, usually the steps suggested by the government, at presently it is all at the government level, is to inspect the dam and carry out the detailed investigation with regard to the health of the dam. This is with regard to the structural stability. But structural stability is not the only thing which creates a trouble in the dam. The problems of the dam, the danger to the dam arises from things or factors which are beyond the structural weakness. The dam may be strong, no doubt about it. But if a flood which was not predicted, which is called a design flood, hits the dam, what happens? Unfortunately, when the dam technology came in the middle of the 19th century, there was no rainfall data. The great engineers estimated the flood with the help of some kind of a mark in the river side, that whenever the flood had come in the history, the water had come up to this level. So that level means they calculated, they said that, all right, it amounts to about 1 lakh cusecs or 2 lakh cusecs. That could be the maximum water that is expected. Then with the help of some little bit of rainfall data, 5, 8, 10 years at that time, the design flood was calculated. This has happened in case of most of the rivers in India. Even after the Indian Meteorological Organization started functioning before the 20th century, the data which it generated, which was available in the post-independence days in 1950, 60, was not sufficient, because usually you require data of more than 50 years or more than that to understand the probable maximum flood. The best thing is to actually to see the river flows. Those data are also available, not available. As a result, at that time, it is also thought that the standards for measuring the flood is a design flood of 100 years. And on that basis, the dams were constructed. The second issue is, about 50 years back or more than that, there was no technology to assess the earthquake intensity. There was no borehole technology to dig and find out how deep the rock is before constructing the dam. In fact, this was one of the questions which I very strongly raised it in the Mullapariyar, that the dam is built on something, nobody knows where the rock is, because at that time when it was constructed, there was no borewell technology. It is constructed, and we believe that it stands on a rock, because whatever they dug. But that's all, it's a belief. Beyond that, there is nothing. In the cross-examination of witness, in fact, we could get the admission that yes, at that time, that was the technology, and it was built like that. there was no borewell available to dig and find out what sort of the rock it is, how deep it is it a shallow rock? Nobody knows. So like this, dams are constructed, and if something happens, untoward thing, the flood comes, which is beyond the design flood, then the dam may fail. The modern concept is to calculate the flood, that is called probable maximum flood. That is calculated by the hydrostatisticians by extrapolating the available data of 100 years, whatever is available, regression analysis they conduct. Then they are able to go back to 10,000 years and simulate it and calculate. Usually the PMF, that is the probable maximum flood, is almost double than the design flood, which we have been using for decades to build dam. In fact, this issue came up in Karnataka in 1980. The dam was designed for design flood. Then the World Bank, which was the funding authority, came and said, sorry, you better redesign it for the probable maximum flood. Since the World Bank was the funding authority, Karnataka government had no choice, and they readily agreed, and rightly agreed, to do that. But before the Karnataka government could redesign its dam and agree, the Department of Railway objected, saying that on the assumption that the design flood is already 7.5 lakh cusecs, we have constructed the bridge below the dam. Now you are saying it is 10 lakh cusecs. What do you do with that? Then the Karnataka government said, that is your problem what to do. As far as we are concerned, our dam will be constructed for the PMF of 10 lakhs, that's all. So that's how the issue was overcome. Then some arguments are raised. Then it was said that, all right, if the bridge gets washed away, it gets washed away. But dam has to be constructed for PMF. Now, what happens to the dams which are already constructed in India? Mullaperiyar, it is not constructed for the PMF. It was constructed for some kind of a design flood at that time. So we tried to argue, which of course was not accepted, that if the PMF now calculated, which turns out to be about 2,25,000 cusecs, way to hit the dam, the maximum water level will go above 155 feet, up to 164 feet as per the IIT professor, Gosain, and the dam will be topped by the water. The dam will collapse. That was the case built by Kerala. But Central Water Commission said, according to our calculations, the PMF will be lesser, and therefore there is no danger to the dam. Whether Central Water Commission is correct or not is a different matter, but that is the judicial verdict now. So we have to accept the judicial verdict. We accepted it. Now, let us think of the dams around the country. What to do? How do you address these dams, which have been already constructed for the design flood or for some kind of a general study on earthquake? And today they fall in the high earthquake zone. What happens to them? There is simply no answer. We are all sitting on this danger. Nobody knows, and nobody wants to do anything because the cost is enormous. If the dam has to be rebuilt, the cost is enormous. But it doesn't matter. If the human lives are considered important, they ought to be considered, and the state has to rebuild. For instance, Mullaperiyar Dam, it was proposed, the Kerala government offered, in fact, it gets no benefit out of this dam. But even then they said, in order to protect the lives of my people, I'll offer to the state of Tamil Nadu a brand new dam at my cost, which will cost me 300 crores. But the state of Tamil Nadu refused, and Supreme Court didn't approve. So that's how it happened. But that's a separate matter. But what happens? There are so many dams in the country. There are dams in Andhra Pradesh, there are dams in Karnataka, there are dams in Maharashtra, there are dams in Madhya Pradesh, there are dams, Bakra Dam is there in northern India. So what happens to these things? How safe they are? To address this problem, a bill has been introduced in the parliament, Dam Safety Bill. But this Dam Safety Bill is simply an administrative exercise which is already being carried out by the Central Water Commission and the State Water Resources Department of taking inspection of the dam regularly and reporting. Beyond that, there is nothing in the Dam Safety Bill which has been proposed by the central government, and the bill is passed in the Lok Sabha. I don't know what happened thereafter. I think it is referred to the select committee, but anyway, it is still a bill. Must be pending in the Rajya Sabha. So this remains how to tackle this issue. Now, if you go to the liability theories, which the Supreme Court had occasion to address, which the courts in England and United States of America addressed, there is divergence of opinion. There is a clear divergence of opinion among the judges. The judges differ. If you apply the principle of Rayland versus Fletcher, a strict liability theory applies because storage of water, particularly the large dam, is not a natural use, right? If it is not a natural use, then whoever has stored is strictly liable for the consequences arising therefrom. So strict liability should apply. In England, the question was not seriously considered, though the Rayland versus Fletcher arose in the case of a small reservoir. But when the question was considered in the United States of America in respect of large dams, the view taken by the American courts is that this principle of strict liability will not apply in case of large dams because the benefits which public gets out of the large dams are so enormous that we cannot impose strict liability burden and obstruct the development of construction of dam and the prosperity which it brings to the people. Therefore, American courts did not apply strict liability theory or a no-fault liability theory in respect of the big dams. The question came up for consideration in India in modern cultivators case before the Supreme Court way back in 1965. Justice Hidayatullah considered the law very extensively. He referred to the American decisions also and took a view that Rayland versus Fletcher doesn't apply in case of any escape of water caused by breach of canal, because that was the subject there. So Rayland versus Fletcher strictly was not applied in that case. But later case, Supreme Court couldn't interpret what Hidayatullah had decided and said, Supreme Court in Ordon cultivators case, the Supreme Court has modified the Rayland versus Fletcher and it has applied the fault theory, that is, nobody can succeed without proof of negligence on the part of the dam owner. So the J. Lakshmi case decided in 1994, Volume 4 SCC 1 at 16 page takes a view that in modern cultivators case, which is the citation is 1964 Volume 8 ASCR 273, at 283, Hidayatullah very clearly says that Rayland versus Fletcher is not applicable in the circumstances. But in J. Lakshmi case, the court takes a view that Rayland versus Fletcher is modified, right? So it's not the modified, actually it is not applicable. That's how the Hidayatullah had said. Then the later case, that is Ora versus Sadiq Bhai versus Ora Sadiq Bhai versus Gujarat, 2016, volume 12, SEC 1. It is an interesting case. This case arose out of release of 60,000 cusecs of water from the dam. The owners in the downstream land sued the state government for negligent release of water. The Supreme Court did not apply the strict liability theory. It applied the negligent theory of negligence and held that state was negligent in releasing the water. In this legal interpretation, Supreme Court laid down one important principle that the modern technology is available for the dam owner to forecast and predict the likelihood of arrival of flood. And in preparation of that, if he has taken a reasonable step to keep the buffer in the reservoir to absorb the flood, then he is not liable. But in the facts of the case, the Supreme Court found, Justice Sikri, that the dam owner, that the Gujarat government, had not done that. And they have been guilty of not keeping a space for the incoming flood, or not predicting the flood and not keeping a space for that. And therefore, they were held liable for negligence and payment of compensation. So we now have this legal difficulty, even if the private law were to apply. If the class action were to be initiated against the dam owner, and if Article 3 doesn't apply, 300, sovereign immunity, this question is not so far decided. What is the liability of the dam owner? Is it a strict liability? Is it a fault liability? Or is it an absolute liability? Supreme Court in 1994, in J. Lakshmi case, also refers to the absolute liability enunciated by the Supreme Court in MC Mehta case. So what are these three liabilities? If it is a strict liability, there cannot be any defenses by the dam owner except the defense of act of God, or it was done under the authority of law. Beyond that, the dam owner cannot have any defenses if strict liability theory applies. If a fault liability theory applies, that is, negligence is to be proved, then certainly the owner of the dam can take various defenses. He can say, I didn't predict it. I have constructed the dam as per the standards. This is something happened beyond my control. Various defenses are available apart from act of God. If the absolute liability theory applies, which Justice Bhagwati enunciated in MC Mehta case in order to checkmate the industrial disasters, probably he had in his mind what had happened at that time in 86, Bhopal. In fact, it was usually said in the Supreme Court corridor, he has written a judgment for the Bhopal already. So in his theory, which is very interesting, he said, if you have an industrial complex dealing with hazardous goods, even act of God cannot be the defense. You are absolutely liable. That is how Bhagwati ruled out, under all circumstances, any defense that the Bhopal, that is Indian Carbide, can raise against the disaster which caused in Bhopal. Now, if the strict liability theory were to apply in case of dam failure, then the state is strictly liable to pay compensation as it is paid in motor vehicle cases or in land acquisition cases based upon the expectation theory, and that will be an enormous cost. So how to strike a balance? Therefore, a legislation is necessary from the parliament addressing this question of dam safety. A proper authority has to be created, a stronger authority. I would say that the state of Kerala has created a better authority. It is headed by a retired judge. There may be criticism that why judges head the authorities, but a authority being headed by a person from the judiciary gives kind of an assurance to the people to go before the authority and raise the issues. If it is a dam safety organization as presently proposed under the bill, I don't think it is going to really address the problem which the dam failures may face. A stronger authority like the authority in Kerala is more advisable. Then we need a legislation to address on this common law theory and make it clear strict liability is available or is applicable, or the absolute liability theory is applicable. I would feel that in matters of life, there is no question, everyone should be protected. If that is the cornerstone of our jurisprudence, Article 21, we'll have to apply absolute liability theory, which Justice Bhagwati propounded in MC Mehta case. Then work out a scheme for payment of compensation. The Act may bar this, the jurisdiction of civil courts, can provide for establishment of a tribunal immediately if the disaster takes place. Then the tribunal will immediately address to the questions. There could be a method of payment of compensation because the compensation principles can differ. It need not be strictly as paid in the motor vehicle case, but there should be a reasonable compensation, as Supreme Court has said, because it is no more a fundamental right to property, but there should be a reasonable compensation. So a scheme should be provided as soon as a disaster takes place to notify the affected people, then pay them the compensation which is due to them. Unless something like this is created, we are going to be in serious trouble. Apart from this, the parliament should also address at the national level seriously whether it is necessary to clear the old dams. In the United States of America, in the last 20 years, nearly 1,300 dams have been cleared. Some are cleared for restoring the environment. Some are cleared apprehending danger to the safety of dam. So we must have a policy at the national level. What is the life of a dam? If the people feel fearful about the existence of some dam, which they think it is unsafe, then consideration must be given to the wishes of the people also. We cannot just decide on the basis of scientific opinion or technical opinion that the dam is safe. Common man in the street cannot live based upon technical opinion. It is a serious matter of policy the state will have to take, whether technical opinion is sufficient to make people feel assured. Most of the cases, it is not so. Therefore, These questions have to be addressed by the Parliament and lay down the correct policy with regard to the replacement of the dams if they are more than 100 years old or 150 years old, or if it is found that the dams are constructed which does not reasonably meet the test of standards as applied now. And if the dam structure cannot be modified to provide for the spillways to carry the excess flood, then we must immediately think of constructing in the downstream a dam. A simple dam is not going to cost much. The most of the money is spent in construction of irrigation projects in the canals and payment of compensation. A dam by itself is not that costly. As I said, in case of Mullaperiyar, it was just 300 crores and it can be done in 5 years. So dams can be constructed immediately in the downstream with some sort of a urgency, and the threat which people live perpetually in the downstream can be addressed to. This is very important at the national level. Now let's see what will happen at the international level. As you all know, international law is the vanishing point of jurisprudence. It's a soft law. It's a morality. If a dam in the upstream state were to break, the downstream state literally has no remedies. What can you do? If there is a treaty, the treaty provides for some sort of a adjudication by an independent authority like International Court of Justice or arbitration, the matter can go. But I have not come across any treaty in the world which provides for such a mechanism. And the International Court of Justice has no compulsory jurisdiction to adjudicate on any issues. In fact, that is the fundamental principle of international law. The most important thing why people say there is no rule of law in international law is because there is no compulsory adjudication of any disputes. The maximum what you can raise, an aggrieved nation can do is to go to the Security Council, and Security Council, if approves for any sort of a remedy with the help of 5 veto powers, then something can be done. Otherwise, nothing can be done. Therefore, in the international order, in the international field, this is something which has no answers, except that in general, we all say state responsibility exists. State is liable to pay for the damages caused to the downstream state by its acts, acts and omissions. Fine, there's no doubt about it. To that extent, the law is developed, state responsibility. There has been an attempt to have a convention with regard to the state responsibility by the United Nations. And even otherwise, customary rule of international law is well developed to hold a state liable for causing a damage to the other state, either by release of floods or by backwater effect. If a downstream state causes an injury to the upstream state by backwater effect, then it is liable. Similarly, the upstream state is liable for causing injury to the downstream state. There's no difficulty. But beyond this, there is nothing which can be done. The only remedy in international field is to go for diplomatic negotiations to redress the grievances of the states. The international humanitarian law has imposed at least one obligation by Geneva Convention that during wartime, during the war, in armed conflict, the states are under obligation not to target the dams. Whatever may be the grievances, you can fight a war, but you should not, the state has no right First of all, state has no right under the present international law to wage a war except in self-defense. And if it is compelled to wage a war in self-defense of its territorial rights or whatever, then the state as well as the other state who are in the war field are under an obligation not to target the reservoirs or dams, as it will cause mass disaster, which is not in the interest of either of the state. So to that extent, the international law exists. Beyond that, nothing as such exists. Therefore, going back to the problem, to sum it up, the state responsibility at the state level is threefold. First thing is to provide a remedy to the individuals to sue the state or owner of a dam, whoever it is, for damages caused to the individual or his descendants. Second is an obligation on the state to provide for disaster management authority to take care of immediately the problems of people who get displaced, provide them food, etc., medicines, and rehabilitation. Third is state to monitor as a preventive measure the health of the dam and take care to allay the fears of people. These are the three things. And when it comes to the state responsibility with regard to the liability, there are three doctrines: fault, no fault, and absolute. I think we should apply absolute liability theory. And in this regard, the parliament should pass a law clarifying or abolishing the present common law system and erecting a separate mechanism for payment of compensation on certain fixed scale to those who are affected by the dam failures. And lastly, the parliament should take measures and lay down a clear policy with regard to the replacement of old dams by new dams based upon certain criteria. And in this regard, the central government may have to fund also, because the purse is usually with the center, though irrigation or water is a state subject under entry 17 of the state list. And it is so even in respect of interstate waters, except that in interstate water, you cannot take more than your equitable share. And what is equitable share is to be decided by agreement. If agreement is not possible, then you will have to go to the tribunal and break your heads. That's how the law stands. So with these things, I thank you all for giving an opportunity to speak and explain the law, and in the process, learn to myself a lot of things which I had myself not seriously paid attention, particularly with regard to the absolute liability and other things. Because when we addressed Mulla Pariyar issue, it was addressed from a different angle. It was more of a judicial review because some public interest litigations are filed saying the dam is unsafe. Court said dam is safe. Then the Kerala passed the legislation saying that, sorry, you can't store it beyond 136, which the Supreme Court later said, sorry, it interferes into our judicial power, you can't do this. That's how the litigation went, but that is separate. But broadly, this is how the state responsibility at the federal and at the international level has been, which requires to be reformed, developed to allay the fears of people. Thank you very much, sir.
Thank you.
Thank you
very much, sir, for that wonderful presentation regarding how dammed our rivers to that extent. Taking a cue from that, in the jurisprudence regarding pollution, the Apex Court and our High Court has said that, and of course, even otherwise, you cannot expect the serenity of the Himalayas. If you want some sort of development, there is a probability of pollution also coming in the balanced development to what extent you can expose your citizenry to the risk. Is it worth the risk, or I mean, different factors, like you said, sir, there are different nuances to it. Let us get the comments from Justice Ramkumar, sir.
Thank you, Shyam. Excellent articulation and wonderful presentation. In fact, your screen sharing. From the screen sharing, I think these scary dam disasters probably may embolden our former PWD minister to say that if dams can fail, why not Palariyuttam Bridge? Wonderful. And you reverse the word dam. I am madly ignorant of this subject also. Of course, Rylands versus, we have gone a long way from Rylands versus Fletcher. One day, I think the Supreme Court may say that constitutional torts will overrule the sovereign responsibility of the state. I don't know. Wonderful articulation. Thank you, sir.
Thank you, Justice Ramkumar, sir. We can just hear from Justice Sunil Thomas, sir, before we go further. Sir, please. Sir, you have to unmute, sir. You're muted. You have to unmute. Yes.
Definitely, it was a wonderful session. So thank you very much, Mr. Senior Advocate. I just had one doubt. See, in the Mullaperiyar issue, the stand taken by Tamil Nadu is that we will not permit a construction of a new dam. And in the unlikely event of a dam collapse, cannot the liability be fastened on state of Tamil Nadu? Then secondly, for the Supreme Court to say that this dam is safe, there one condition was that one reason was that even if the dam collapses, the water can be contained in the Idukki reservoir. That depends on one aspect. That if Idukki reservoir is full, there is a further failure of cascading effect. It may affect Idukki Dam also, then it may not be able to contain it. The second possibility is that even if the Mullaperiyar Dam collapses, the water will flow along the old channel and reach the Idukki Dam. Assume that the debris of Mullaperiyar Dam gets piled up and takes a different course of the river takes a different course. That's another issue. Water may not go to the Idukki Dam, and it may have a very, very cascading effect. It's a serious issue. How do you look at that issue?
Yeah. First thing is, the Supreme Court has not decided anything with regard to the claims which an individual will have in case a dam collapses. At the moment, it has only said the present structure which Tamil Nadu owns cannot be demolished. That's all. If the water is released from the Mullaperiyar Dam due to the dam failure or due to dam topping, the flood gets released. Certainly, it will go into the Idukki Dam. But we're able to demonstrate before the court, which the court ultimately didn't address for other reasons, in the second stage of litigation, that there are situations when the Idukki Dam is full. At the same time, the Mullaperiyar Dam is also full. We're able to show with the help of certain instances in the past when both were full. When both were full, if the PMF of 2.25 lakhs or 2.5 lakhs estimated, or in fact, Gosain said it goes to 3 lakhs in his revised report, where to hit the dam when Mullaperiyar is full and Idukki is also full, what happens? We also calculated the time lag between the Idukki and Mullaperiyar. And by calculating that, and we also showed, in fact, I had a detailed cross-examination of the witness, and he admitted each one of them, how much water the Idukki can release if a news arises in Idukki Dam chief engineer that Mullaperiyar has failed. It has burst. right? Then immediately opens all the gates. How much he can throw out? That also mathematically we obtained admission. Therefore, we told that Idiki will not be able to absorb the floods of Mullaprayar. On the other hand, the Idiki itself will fail. It will not be able to bear the load which comes from Mullaprayar. Then their answer was, this is all hypothetical. We said, it's not hypothetical. There are instances where both on the same dam in the past, they are full. What is hypothetical is the flood. Well, it is hypothetical, but if it happens, when both that are full, the catastrophe is going to take place. It is going to wash out hundreds of villages, towns along the Periyar River in the downstream, affecting people in a very big way. This is how we were able to do it. But the Supreme Court said, according to them, the PMF is less and that can be managed. And it is already a decided issue in the first round of litigation, Mullaprayar, because the first round of litigation, unfortunately, it was a PIL and it was all based upon the affidavits. I was not there at the first round, in fact. It all just went on the basis of whatever was material available. In the second round, state really did an excellent job. The best of the witnesses were produced. Everything was presented to the court. But the court said, it is an adjudicated fact. We cannot reopen. But in case something were to happen, we constitute a committee which will periodically inspect the dam and see that the dam is kept in a healthy condition. Let us hope it will be so, but that is how it is. But this will not bar the filing of suit somebody wants to file for the purpose of compensation if the dam fails. He has a right, provided he proves that strict liability theory applies, or if absolute liability applies, no issue. In case it doesn't apply, if negligence has to be proved, then he has to prove the negligence. Only those are the eventualities.
So thank you very much.
Thank you.
Thank you. Thank you, Sunil sir. K. Vijayarao.
Good evening, sir. Excellent talk. I'm basically from the aviation field, but dams have been an interest because I come from the village of Polavaram, where the dam is being constructed for the last 75 years. And just last
across Godavari.
Across Godavari, yes. And just last October, now 3 states have raised an issue, which is Orissa, Chhattisgarh, and Telangana, saying that if the Polavaram Dam is at full thing, will the temple town of Bhadrachalam be affected? And then a lot of reports going back and forth, IIT reports. So, but the end of the day, what is happening is dams, a dam in the making for 75 years has created so much of havoc. In fact, last March, I was present at the dam's site by virtue of being from the ruling family of Polavaram. So we had some festivities there and we had to go there. And the amount of damage that I have seen, I just sent those photographs to Shyam sir. I just clicked those photographs. Sir, the Godavari river has now become a stream. That is the amount of damage that is taking place to the river Godavari. I mean, the purpose also has not been served because half the canals connecting the Godavari and the Krishna have not materialized. And yes, I do agree. Today, Telangana is scared that the PFM, what to do with the PFM, and they're working on it. But sir, as you once said, once the construction starts, and second thing is, sir, the construction has changed at least 8 companies. So now who will take the ultimate liability for a weakness in that or a flaw in the building of the dam? So all these questions will come up, sir. So what we are actually doing is we are sitting on a keg of dynamite waiting for it to explode, and then decide, "Acha, this would have been the damage." And that is a very sorry thing that I hear now. Like just as we read about Tamil Nadu refusing the offer from Kerala to build a new dam. Why would they want to refuse it? I mean, is there any logical reason that Tamil Nadu should refuse to the offer given by Kerala government? They are not denying them the water. They are not denying them anything. They're saying, you take the water, but I am trying to take care of my residents. So are we going to be reactive in certain issues, or are we going to be proactive in certain issues? I mean, like you said, the court said that will happen later and we'll have to look at it at a later date. But sir, that cannot be the reasoning, right? Correct me if I'm wrong, Katarki sir.
Yeah. Yeah. So as far as the Polavaram is concerned,
Yes, sir.
I was involved in that on behalf of the state of Odisha.
Yes,
Then I had to recuse myself because the state of Karnataka filed intervention application. Then I said, the Karnataka government, I can't appear for you. I'm already appearing for Odisha. And for Odisha, I said, since my home state is there, I don't want to get involved into this. So that's how I had a short tryst with the Polavaram. The basic issue in Polavaram is the matter was decided by the Godavari Water Disputes Tribunal with regard to the Polavaram barrage. This is in the downstream, it comes almost little near the sea. The flood at that time estimated was about 46 lakh cusecs, if I'm right. It was about 10 years back. I'm recollecting. But the present estimation of the flood is much higher than that, based upon the present technology and the standards. So Odisha state said that if you construct this barrage, and if the newly estimated flood were to impinge upon the dam, the backwater will be much more than what I had agreed at that time of adjudication. So that's how the Odisha has raised the issue. And original suit is filed in the Supreme Court and it is pending matter. Hope Supreme Court will finally decide one way or the other. And in the meantime, there are certain alternate proposals being worked out, like Pettisila lift irrigation to lift the water and all Andhra has done. But this is a very complex issue.
It's a
Very difficult to say.
area, sir. Where the lift irrigation
and with regard to the
place. Sir,
yeah,
I am
with
worried
regard to
because...
Mullaperiyar.
Yes, sir. Sorry, sir. Continue,
With
sir.
regard to the Mullaperiyar Dam, you said, what is the logic on which Tamil Nadu rejected the great offer of Kerala? Well, according to me, there is no logic. But their fear, it seems, which they didn't tell us, was that the present dam is constructed almost at the edge of the lease land for 999 years. If the new dam has to be constructed, it has to come in the land which Kerala owns. So for that new dam, the Kerala may not execute a lease. That is their fear. Looks like. They didn't tell us, but that is the real fear. If Kerala government had agreed to execute the lease, it would have been different. But we can't agree to the 999 years. No democratic government can agree in these days. Certainly, it can be agreed for 99 years, but it can't be 999 years. And it has to be based upon the fresh terms of the lease. The payment of a license fee and other things are different. And secondly, Kerala also has some kind of a interest that if I am spending 300 crore, I want to share some power that is being produced at the new dam structure. That's how the dam was devised. Kerala, the Tamil Nadu did not disagree with any of these things, but they say there's no need to construct, no need to construct. So they went on talking in the negative language. But the underlying issue, it seems, it was sure that Kerala will not execute 999 years lease in respect of the additional land on which the new dam is going to stand. But it could have been worked out At one stage, I told, when I was arguing in the Supreme Court, Justice D.K. Sen, D.K. Gupta asked, "Are you ready to execute a lease?" I said, "We'll execute a lease, whatever is permissible in accordance with law." Then he threw back on his chair. He understood the point. Then I said that forget everything, my lords, the lease, whether I execute, let it be under the orders of the court under Article 142. You devise a regime that is more durable than any lease executed by the state. Under the scheme of the Supreme Court, the new dam can be constructed. But somehow it didn't appeal to them.
I think the Polavaram Dam to success is going to be another 10 to 15 years. It will not see the day of light before that, sir. I mean, what I went and saw the work in the month of March. I happened to go there because, sir, there are two temples there, come down from the Chola dynasty, and we are the hereditary trustees for those temples. Where my Polavaram estate belonged to my grandfather, sir.
Okay, that was the Jamindari. Polavaram
Yes,
Jamindari.
Yes, I am the direct descendant, sir. Now, I am the hereditary trustee to those two temples. So I had to visit the other one, which is 6 kilometers upstream from Pattisima. And that is where I got those photographs when I went there. And it was really disheartening to see the way the village, the river was being turned and at every point and blocked at every point. It was really distressing to see, sir. Because in the rains, sorry, sir.
The normal flow has come down because series of dams are constructed in the upstream. The dependable flow, what you used to get, it is not available. What you get is only sometime a flood, which is of very high order than what it was earlier.
Earlier, sir, to visit, mine is an island temple. Sir. It's a 22-acre island temple with only the temple there. So earlier, I need to have boats to go across. So for Shivratri, we had tendered boats. 18 boats would be hired of a 72 seating capacity to ferry the pilgrims back and forth. Today, they can walk across. I mean, that is the level of water in the river Godavari. It was really sad this time.
Right.
Yeah, I'm told it's a very beautiful place. I have not visited.
Sir.
I've gone up to the Vansadhara and that area.
Okay.
The Srikakulam, then went further down to the Parkalmedi.
So next time you intend visiting, let me know. We can make arrangements, sir. It's a rustic place, nothing, no hi-fi thing, but just a small guest house, 2 rooms, attached bathroom, basic amenities, sir, on an island. So,
good.
Thank you, sir. Thank you very much.
Thank you, Rao, sir. Najib, you got
Thank you.
So excellent insights to not listen to me, at least to me. So I do have a question. See, what will be the take of the
Najib, can you be a bit more audible, please?
Can you hear me?
Yes, now we can.
Yeah, sure.
There's an excellent insight on a topic which I have not listened to before. Sir, what if a privately owned dam goes bust? How will it be?
The same liability.
There won't be the sovereign protection.
Only in case of government, our worry is the government may invoke, so far it has not invoked, but may invoke protection under Article 300. That is, it is a sovereign function, therefore it is not liable. As far as the private is concerned, there is no such protection. Only question is whether strict liability applies or a false liability applies, or absolute liability theory of MC Mehta applies. That's the only question. Most probably in case of small private dams, they will apply the false liability. In case of big dams, we are all advocating for a strict liability, or the best thing is to go for the absolute liability.
Thank you. Thank you, sir. Now for the concluding remarks, can I have Vijay, please?
Yes, you gave me a surprise.
Yeah, that is what I am specialized in.
Sir, it was a fantastic articulation. I just had one doubt. You spoke about dam safety. What about the water which is released at times without any? What are the precautions for release of water upstream in most of these Himachal Pradesh and Uttarakhand? We see water being released without proper precaution. Now, what is this? Who should be made responsible? The management of the dam, the state, or who should be made responsible for that?
So
Sorry.
in case of, right, sir, in case of the release of water without notice, certainly the owner of the dam would be liable. This is what happened in the case of Ohra Rasik Bai for the state of Gujarat in 2016 Supreme Court decided. The owner of the dam, in that case it was the state itself, released 60,000 cusecs of water, apprehending that if it is not released, it may affect the safety of the dam. So it was a choice they did. Then the Supreme Court said, look here, you should not have landed yourself in this situation. If we had kept the some kind of a buffer in the dam or a space for absorbing the flood, you wouldn't have landed in this trouble, and held the state liable for negligent operation of the dam and directed for the payment of compensation to the downstream lands which suffered on account of this abrupt release of 60,000 cusecs of water.
What I asked is that Hyderabad engineering students had been to Himachal Pradesh, and while taking pictures at the canal, the dam released the water, and this happened in 2014. About 25 students have died.
Yeah.
So
I seen that sad video, that very sad video.
True. In fact, one of our advocates' son, who is a regular participant in the group, is also one of those tragic, that suffered a tragic loss.
Very sad.
Very sad.
This we were considering back then as to what is the scope. Sir, it was very authoritative. Yeah.
Sorry, sir. All these things are presently addressed by common law, that if you're agreed, go and file a suit. That's no answer actually, because the dam is such a big issue, and the kind of challenges it throws to the individual to go and prove that the operation of dam is not was not carefully done. It's not easy for an individual to lead the evidence and prove. Therefore, some sort of a tribunal establishment under special law would be of great help in addressing these issues.
Thank you, sir. It was very authoritative on your part to explain all the nuances of the dam safety. Thoroughly enjoyed your lecture, and I'm sure I'll be watching this in YouTube again. Though I have heard you at length, I'm definitely watching this video in YouTube whenever Shyam puts it across.
I will do it immediately.
Because it's very interesting, because we don't come across this kind of a subject on a day-to-day basis.
Thank you, Vijay. Before we conclude, we have Maurya also with a question. Maurya, please.
One advice to K. Vijay Rao is that next time, sir, don't engage boats, engage buses.
No, sir, I cannot. The buses, no, sir. The buses are come from. No, the buses come from Rajahmundry and Kovur.
And Rao sir, on the lighter vein, it is high time you learn deep scuba diving also. Might have to go under to do your.
No water. River has dried up.
I have no water, Shyam. I have to learn.
Now no water. Okay.
Yeah, exactly. There's absolutely
okay.
no water.
Now the all yes, please.
Yeah. Good evening, everyone. So I'm currently a research scholar with the Center of Law and Governance, JNU. And my current PhD topic is Law, Justice and Governance, Dam Safety Governance and Disaster Management. So this particular session has been extremely helpful for me. Due to COVID, I was not able to do my field work, but I would like to share what I have noticed during my pilot studies, and as well as like to raise some questions.
Sure.
Sir, you have basically given a very nice summarization of how the dams have been constructed and what are the situations of failures. So as per my understanding, there are two broader failures. The first is the safety of the infrastructure itself, and the second is the operational failures that we see in the name of flood management and other stuff. During my pilot study, I went to MP, and there the Chambal was actually overflowing in the month of September in 2019, and because of that, the dam which was constructed on the border of Rajasthan and MP, that is the, I'm forgetting the name right now, but the particular dam, they have to basically make a stream in order to make the flow and release the pressure that was coming on the dam and let the downstream areas flood, because there was so much inflow in the Chambal River that that particular dam was not able to take it. So in order to ensure that there was this infrastructure safety, they induced floods in the nearby areas. And this has been a common concern in upcoming time when there is a huge climate change and basically the monsoon has becoming more erratic. So I would like to raise the first question on how we should proceed in such situations, because this is not just an ecological problem, but this is also becoming a governance issue at a major level now. And the second thing that I have noticed, that when we are talking about common law, or even when we are talking about disaster management, what we are talking about is compensation based reliefs that we basically give to the victims. Is there any other mechanisms apart from talking just about compensation? Because see, once we have lost our life, once we have lost our livelihood, compensation of any amount cannot be come to that particular measure. So is there anything that can be done, not just as the relief measures, but also at the preventive measures also? Because the state is again and again failing in that. This is a very nice point that is raised by KVG Rao sir also, that what is the problem, why the states are not coming to an agreement. The most important thing that I would like to notice, that I noticed, and I would like to say that the irony is that the State Disaster Management Board is headed by Chief Minister, and he is also the political head of the state. So isn't this that there are two duties suddenly given to one person, and he's not able to make a rational choice over here? Like, this is what we have been noticing in most of the governance issues, that there is a lot of give and take that you have to come across, but this is a major issue. This cannot be led to just the whims of political parties or the political gain. So yes, these are my observations, and these are two major questions that I would like to put. Please enlighten me in this respect.
Thank you. Interesting question. And I'm glad that you're a student studying in the dam safety and issues relating to the governance of the dam. As you know, the construction of the dam in India is decided still as a matter of executive policy without being guided by any legal standards. When a state proposes to construct a dam, it doesn't notify to the people, at least, that we are constructing a dam. It does not disclose its plans. It does not disclose its designs. It doesn't even tell who are the beneficiaries who are going to get water. Everything is secret. That is how the system has been operating. Unlike what you see in the West, the designs are kept in the public domain, inviting comments. The beneficiaries who are going to get are also being told, because there could be somebody else who wants to be beneficiary. He may say that, why can't the canal come to my village? Why only up to that point? He may have point to tell. So all these things are not addressed in India. It is still a simple administrative decision taken by the state government under the old Irrigation or Water Resources Act, whatever we have. Right. At least Kerala has passed a better law in 2006, which has laid down some procedure for that, but that is not sufficient again. So the decisions are taken in a very arbitrary manner when a dam is constructed. The first and foremost question is, how do you manage the floods? Do you manage the floods in such a way that you get the maximum benefit out of it? There are various theories. It is a very complex hydrological theory. Some dams are built against the flood water. Some dams are built against the minimum available in the river because they want 100% dependability. They don't want to be against the flood. So then how do you manage the flood that comes into the dam? How do you expel it? Do you keep the space for absorbing the flood? These are all the serious questions which have to be decided while framing the rule curve of a dam. That's a very serious policy matter, but unfortunately, it is framed in such a manner which nobody understands because it is too technical. Even the best of the administrators who are supposed to guard the public interest and the bureaucracy, even they do not understand much out of it. They blindly agree to whatever comes from the technical side. And technical side are very good people, no doubt about it. They have the best interest of the state in their mind, but they go in their own technical way. They are not much concerned about the stakeholders' interest. So overall, we find arbitrary decision being taken. Sometimes the decision is taken in such a way that we should get more water for irrigation. Therefore, they do not keep a space. They'll allow the flood to impinge on the full reservoir level, FRL level. That creates a problem. Suppose you keep a space and the later rainfall fails, and in some year you'll not be able to fill up the dam, then the irrigators will create a problem. They complain, why didn't you store the water when it was available? So all these matters are serious matters which will have to be, which the government decides, but well, they decide it in their own way, which is not a transparent way. As a result, the people have no confidence in the decisions. They may be the best decisions, but they have no confidence because they are all decided in a closed chamber. Now, the second thing, as you said, that Chief Minister himself is the head of the disaster management authority and all. How can he take a decision? Well, this happens. This is one of the important subjects with regard to the water resources management again. There has been a suggestion for creation of a regulatory body for the water, where the construction of the dam, operation of the dam, all these things are decided by an independent regulator who has sufficient independence to take decision after hearing the stakeholders and after hearing the government takes a decision. But still that body has not come in India, and we still continue to operate in an archaic style where decisions are taken at the technical level and in a closed chamber. You can call it a starved chamber, and things carry on like this. It has been happening and it will continue to happen unless some kind of a reforms come in the water sector.
And regarding compensation, is not rehabilitation also possible? She asked about compensation also.
Oh, sorry, I missed that question. I'm sorry. Thank you, sir, for reminding.
Yeah.
See, rehabilitation is actually a fundamental right now. Supreme Court has said. Certainly, rehabilitation has to be carried out by the state government when it constructs a dam. Earlier, the state government addressed only the landowners who had lost the land and paid them the compensation under the Compensation Land Acquisition Act. Then the Sardar Salovar issue brought to the attention of the people. What about the non-landholders, those who do not own the land, who get displaced from the village, who suffer the brunt of displacement, and who is going to compensate for them? Then the Supreme Court took a view that there is a right of rehabilitation. And some states like Maharashtra have created a provision under the Water Resources Act, a scheme for rehabilitation. And under that scheme, the rehabilitation is worked out. In fact, the Narmada Tribunal, which extensively went into the question of rehabilitation, that was the first judicial authority which went into this question. Before permitting the state of Gujarat to construct Narmada Dam, they imposed serious obligations on the state of Gujarat to take care of the oustees or the persons who are to be rehabilitated and lay down the scheme. But even then, there are a lot of grievances, and Narmada issue has been still going on because it doesn't take care of the tribals' interest. Tribals are not given compensation. Only rehabilitation is not sufficient. These are the issues. But certainly, they have an equal right. Not only the landlord should get the compensation for the lands he has lost, non-landlords who have lost their livelihood, who have suffered trauma from the displacement, who have suffered their cultural rooting, who are uprooted and suffer their cultural loss. All these things have to be compensated in some reasonable manner. And for this, again, the parliament has to address it more seriously. At the moment, the executive governments address it in their own discretion, depending upon the pulse and pressure of the local legislators. But some kind of a remedy is made available now, compared to what it was 25 years back. Have I answered?
So, but this remedy is basically, yeah, I would just like to clarify that is this remedy of rehabilitation is only available in the case of dam constructions, or it is actually available after the dam failures also? Because that's a big question. That yes, the construction
It should be available.
fine.
It should be available. It should be available. In case of dam failure, in fact, everyone has a right to sue the state for the damages which he has suffered, to seek a compensation. But so far, that has not arisen in India, except that the dams at Kadakawasla and others failed, where the government gave some compensation addressed in the manner they like on the executive side. Nobody really took the government to task. But that may happen.
Yeah, but even like in the present Dam Safety Bill 2019 also, I was going through this, and section 44 basically states that no court shall take cognizance of any offence punishable except on a complaint made by central government or the state government or a person authorized in this behalf by a national committee or the authority or the state committee. So basically the cognizance itself or compensation also has been restricted in this particular case, and which is like the major question of today's discussion. This is a bill.
Which section is it? No. Which
section
section is it? 30?
So this is 44, cognizance of offences.
Yeah, it is only against the
criminal court.
No court shall take cognizance of any offence punishable under this act, except on a complaint made by the central government. Fine. No court inferior to that of the metropolitan magistrate. That's fine. It is only in respect of criminal liability. Yes. Civil liability is still remains unaffected, whatever it is available under the common law. What is available under the common law may be debatable, but that remains still unaffected.
Thank you for the clarification.
Thank you. Thank you, Maria, for the question. And we have some sad news coming from Delhi. Jayman, please.
Yeah, I'm also getting the information.
Sir,
I think he passed away.
Excellent presentation. I want to submit. See, our Supreme Court senior Advocate B. Shekhar, an hour ago, we lost him due to COVID.
Oh my God, so sorry. Oh, so sorry. In fact, I had a message.
Very close to you.
I had a message.
A very nice gentleman.
2:30, I had a message that he need plasma. I sent a message saying that my son can give plasma.
In fact, during your lecture, I myself and Mr. Shyam was exchanging messages for getting some medicine, but we could not help.
Mohan Shantanu also passed away, it seems.
No, so that is not yet to confirm, sir. There is a message from.
No, the Karnataka people have started already sending condolences.
Somebody has circulated it, but later I got an information that.
Yeah, but
regarding Shekhar sir.
Shekhar is very sad.
Very sad, sir, because
very
happening in Delhi, and medicines. The problem is that we are not in a position to confirm. And what else to say? Very sorry to say.
Shekhar and I and Shekhar traveled to Israel and Jordan.
I know it. That's Jordan what I was telling you. I know that in corridor you were all. I saw you always talking.
Very, very sad. Poor chap.
If this is the fate of a Supreme Court judge, where are we, ordinary people?
Very, very, very.
On the rampage.
Lethal. Very
We
lethal,
are,
very lethal.
sir, it only shows that how ill-equipped we are to meet the crisis. I don't know.
Totally ill-equipped. Absolutely
Correct.
ill-equipped.
Usually we stop at a happy note, but today, what else we can say? Like, I mean, all said and done, let us all keep ourselves safe and see whatever can be done. We were trying to get the medicine from different hospitals in Calicut because there was
Is
some
the-
small stock. But
Is
My
the new
request to you, especially from the people of South India, is that see some medicines which are available, no, which are out of stock in Delhi, that is available in many South Indian states still. Oxygen and all we cannot help because that's a state policy and all we cannot. So if some requirement is coming, even our group may need to act immediately and some.
yes,
Shyam sir, I'll forward you an SMS.
yes.
In Hyderabad, remdesivir tablets are available.
Then
And they will
just
put-
keep
they will
a stock
stock
of that, and as and when necessary, let us collect it and
They are,
forward to Delhi or wherever it is.
they're dispatching it free of cost, only courier charges to be paid. I'll forward you the SMS, sir.
Wonderful, wonderful. sir.
Hyderabad has it, so I'll
It
just
will be a
forward it to
great-
you, sir.
In fact,
Last night I couldn't get a bed in
fact,
Delhi,
our-
sir.
in fact, our
Despite
friend
knowing top
Mr.
doctors.
B.V. Dinesh, who is the founder of Liability,
Live
is
low.
also having in need of medicines.
We'll get it. We'll
Yeah.
somehow or other get it.
Mr. Mohan Katarki sir is a very good friend of him.
Yeah.
Mr. B.V. Dinesh.
No, he said,
he's-
my son is giving a plasma to him tomorrow.
Okay.
They have
Okay.
fixed the time.
That's very good. Wonderful.
Yeah, yeah.
is the new COVID variant attributable to the India-China border?
Cannot
sir.
put anything past
I-
anything, sir.
I am
Today's world.
I have some suspicion. The new mutant
New mutant is
Is
India
China-
specific, they say.
is China's again responsible.
So, I mean, let us forget about who's responsible, sir. Let us
At
think
this
in
point
terms
of
of,
time, we think of the lives, sir. That's all.
I mean, it's high time. There's nothing that is, I mean, even in Calicut and in Kerala, Cochin for that matter, beds are running out. There's no
We've
beds
lost
available.
6 friends, sir, in the last 3 days.
Harish, sir, you want to say something, sir?
Yeah. Good evening. This is Harish here from Bangalore, advocate and member of BPAC, Bangalore Political Action Committee. Mr. Mohan Katarki, sir, thank you for a very enlightening session. It may not be out of place for me to mention that in 2016, we as a civic body, Bangalore Political Action Committee, filed a petition before the Supreme
I know.
Court on the
You had
ground
come to
of
Supreme Court.
fundamental right of drinking water to Bangalore.
I remember.
Yeah, I was there in the court myself along with
Yeah,
Mr.
yeah.
Harish Salve for this.
Right.
Sir, as regards the Central Water Commission and the Dam Safety Organization, which has given a guidelines for dam safety, do you think that is foolproof, and don't you think that there has been more, it is more adhered by its breach than by its compliance as on date? One. Second one is, is it not advisable to have nationalization of rivers so that all water disputes, interstate water disputes, come to an end by default?
Yeah, the first question is whether the guidelines and the standards which the Central Water Commission has prescribed are foolproof or not. I can say only this much.
Compliant.
Yeah, I can only say this much. As already said, that the fundamental question is, these dams were built at the time when the standards were different. And today, if you apply the standard of probable maximum flood and the earthquake intensity, will they stand the pressure or not? Most of them not. Then what steps to be taken? So there has to be one kind of a policy decision that if they do not conform, you will have to remove the dam and construct a new dam. There is no question midway. Now, with regard to the implementation of the policies, to the extent the things like inspection, surveillance, which the Central Water Commission has prescribed, that happens. The committee visit the dams. They do visit the dams, every dam in the country, periodically. They take some inspection and give the report. Then based upon the report, the center addresses to the states. To what extent the state complies is a different matter. But to an extent, it happens. But there is nothing like a transparent structure where an individual can go to the authority and say, look here, this is the technical report. and this is what you have done, you are not done. Or can go and ask a technical expert, look here, your understanding of the subject is wrong. I am telling you it is like this. So we can't question the technical experts, nor we can question the government at present, even if the technical report is in favor of an individual, to get it implemented. So this is the how the state of affairs exists. As far as the nationalization of the river is concerned, at present, under the constitution, the river is a state subject, right? The interstate rivers can be taken over by the center under entry 56 by declaration, okay, and develop the water. Or they can constitute the river board, which is the legislation passed way back in 1956, but not one river board is constituted till today. So it's a dead piece of legislation. And why can't they do it? The reason is this: it is far more difficult for the center to manage the conflicting interest of the users of water than for the state. So at least the states today, as one, fight against another state. If it is the central responsibility, it is like distribution of an oxygen, what you are saying now, that everybody will go and hold the central government by its throat. And center is the central government. It is again decided, things are decided at the political level, and the decisions taken at the political level are political. So center will not be able to decide these issues, the rival claims put by the states, even if it is made a central subject. The center will ultimately dump it before some tribunal to have it decided by an adjudication. Therefore, adjudication becomes unavoidable. This is how Ambedkar thought, having regard to the experiences which he had seen with regard to the Indus dispute way back in 1942. In fact, when the Government of India Act was framed in 1935, the Select Committee in London thought over this. They said that it's too difficult for the center to handle the interstate issues. It will be impossible for them. It is better you leave to them, to their better senses, to sit and come to an understanding, or go to the tribunal, independent judicial body, either the Supreme Court or the tribunal, whatever it is, and get it resolved. So that is how the issue stands.
Thank you, sir. Thank you.
Thank you, sir. As we come to the end of the 198th session, tomorrow in the 199th session, we have the topic with jurisdiction equity. It is the speaker of the day tomorrow would be Honorable Sri Justice A.V. Seshasai. He is a judge of the High Court of Andhra Pradesh. Today, sir, we had a wonderful evening on a subject in the last 197 sessions we have not touched upon, and the way in which we could, the kind of questions, the kind of responses evoked, I would say that had it not been for Justice Sunil Thomas, sir, we would have forfeited this wonderful opportunity to interact on a subject of grave importance, especially to Kerala with Mullaperiyar, etc., looming large on our head. And
let me say one thing. Let me say one thing. I addressed nearly about 20 webinars in last 1 year during pandemic. That today I really enjoyed. It is the best thing I think I have addressed. Not only the subject wise, the kind of questions came and the kind of interaction it took place. It is really a wonderful experience. It is a great learning to me also. And I'm sure we'll have more opportunities in the future to interact with you.
Definitely, sir. You are now part of our family. Like Justice Ramkumar sir used to say, once you are in Letils, you cannot just leave it as such, because you are part and parcel of
you're addicted to it.
I must thank Justice Ramakumar. I heard a couple of his lectures on criminal law. They're really very good. I really understood the criminal law better after listening to his lecture. The way he explained what is cognizance and all these things, I found them so interesting. As a Supreme Court lawyer, we do not get into these nitty-gritties of the criminal law. We have a broad, what we call 136. We usually forget the issues which usually the
cutting edge
trial court lawyers deal with that, and they're very important from the point of prejudice is concerned. We ignore them because we don't know them. That's all. So after listening to a couple of lectures, I really felt you know the criminal law ins and out of it. Thank you, sir. It is always a pleasure.
And we are eagerly awaiting for his masterpiece book to come out so that we'll have a dome of information, sir, wherein we can just go back again and again to get clarifications and further enlightenment. So,
Yeah.
sir, yeah, please. Sir.
Manual aside. And
Thank you. So I would, so I would say, Justice Sunil Thomas, sir, once again, thank you very much. Senior Advocate Mohan Katarki, sir, thank you very much. We expect you to be, we'll be sending you the flyers of the coming sessions as well, and we expect you back on this platform again. On any subject of your choice, sir. And Justice Ramkumar, sir, thank you very much. And thank you each and every one of you for being part of this movement, Littles. So as we come to the end of the 198th session, please do take care and stay safe. Till we meet again 10:30 tomorrow morning. Please note the change in time. It's 10:30 in the morning. 10:30 tomorrow morning. Please do take care and stay safe. Thank you.